and welcome to the second video in week 2 of Laws 3006 Administrative Law. In this video, we're going to consider what is meant by the term decision in administrative law. Now, at first you might wonder why we bother doing this. After all, decision is a perfectly normal English word. But we're talking here about its application in a very specific administrative law context. And strangely, the administrative law definition of decision is broader than you might expect in some ways and narrower than you might expect in others. Let's start with the broad stuff. We know in general terms what a decision is. A decision is any situation in which a person, the decision maker, has the capacity to choose from a number of options. We can have simple binary decisions where the decision maker simply chooses between yes and no. And we can have much more complicated decisions. For instance, when a person's trying to choose a phone plan and there's 15 different service providers, each of which offer 11 different plans. In administrative law, we extend the definition of decision to cover 3 things. First, there are the decisions themselves. Second, there is conduct related to making a decision. And third, there is the failure to make a decision. Now, I'm going to skip over the decisions themselves. They're fairly obvious. They might occur in response to an application. They might occur simply because a decision needs to be made. The government decision maker has options in front of them and they make a choice. Simples, as the meerkat says. Conduct related to the making of a decision is a bit more complicated. Sometimes there may be a range of steps required in order to arrive at a decision. Let's say, for instance, that someone in a government position is accused of workplace misconduct. Another person is appointed to conduct an inquiry into that allegation and then make a report to the senior officer who would make the decision. Can you see there that the decision is going to be made by one person, but a completely different person is going to be doing all the legwork? Now, there would be no point in having a process which only looked at how the decision maker made their decision. They'd just say, I read the report and I used my best judgment. Really, if you were unhappy with the outcome, what you'd need to do is challenge the conduct of the investigation by the report writer. There's a problem with this though. No decision really stands alone. There might be 100 steps taken first. A decision whether to investigate, a decision who's going to investigate, a decision as to their terms of reference, a decision as to each separate step in the investigative process, a decision how to analyse those materials, and all of those things are potentially conduct related to the making of a decision. This problem came up in a case called the Australian Broadcasting Tribunal against Bond. Alan Bond was a businessman, and part of his business was a TV station. The Australian Broadcasting Tribunal was going to refuse to renew his broadcasting licence because he'd been involved in some potentially corrupt dealings. The Bond team, no, not that kind of Bond team, the Bond team didn't just challenge the final decision about the broadcasting licence. They also challenged a whole heap of decisions along the way. I've always thought that they realised most of those challenges would fail, but they were hoping one would sneak through. The court found that all of these little decisions which were really just mere stepping stones along the way to making the big decision, those little decisions are not reviewable. In Bond, the court said that to be reviewable, a decision or the conduct relating to that decision had to be final, operative, or determinative. That's the key phrase, gang. That's the one we expect to read in an assignment or an exam question in this topic. Final, operative, or determinative. The court backed this up in 2 other key cases called Edelsten and the Health Insurance Commission and Kelson and Forward. You can review conduct if it's final, operative, or determinative, and not if it's a mere stepping stone. So, we have decisions and conduct related to the making of decisions. Finally, we have a failure to make a decision. Because, as anyone knows, if you've been hanging out for an important decision, a failure to make a decision can be as important as the decision itself. In a case called BMF 16 against the Minister for Immigration, a man who was a permanent resident of Australia and who qualified for citizenship applied for citizenship, but the minister didn't make a decision for nearly 2 years. Now, if administrative law only allowed you to challenge decisions, then the minister could wait 10 years, 20, because if there wasn't a decision, there would be nothing to review. So in this case, the failure to make a decision was reviewed, and the court found that the government decision makers cannot delay their decision making if the delays are unreasonable. And that makes sense because for some decisions, an unreasonable delay might mean a day or even a couple of hours, whereas other decisions might be expected to take more than a year to assess. The point is that if the delay becomes unreasonable, the person waiting for a decision can challenge that failure to make a decision. So, to this point, you can challenge a decision, you can challenge conduct related to the making of a decision, provided that conduct is final, operative, or determinative, and you can challenge the failure to make a decision. Now, before we wrap up this video, we need to explore three things which are not decisions for administrative law purposes. They're all decisions according to the normal English use of the word, but they're not reviewable decisions for administrative law purposes. First, rulemaking is not reviewable. There's a difference between making a rule and making a decision. A rule applies to everyone, whereas a decision is specific. If the government made a rule that redheads are no longer allowed to drive, that rule could not be challenged through administrative law. You'd need to challenge it in other ways, most likely through the political process. The reason I'm emphasising this is that under our system, we obviously think of the Parliament when it comes to rulemaking. However, by this point in your studies, you have probably realised that many rules are actually made through regulations. They're rules made by public servants and not by the Parliament. They're rules made by the same public servants who make decisions in individual cases. So in each case, you need to think, is the public servant making a rule which applies to everyone? Or are they applying a rule to make a decision which affects just our client? The authority for the idea that rulemaking can't be challenged is a case called Kiowa and West. Don't read that case this week. We'll be coming back to it and it really won't make much sense just yet. Second, prerogative decisions are not reviewable. Prerogative decisions occur when the decision maker is basically told that they have a personal power to make decisions. So, for instance, the governor of each state has a prerogative power of mercy. They can pardon people, they can release people from prison. It's a personal power, and if they decide not to use it, it can't be challenged. The use of this power obviously happens very rarely. It's designed as a final, last-ditch backstop if the criminal law seems to be leading to injustice. So an example was two men named Elias and Gordon, sailors on the HMAS Australia in the Second World War. They were tried and convicted by a court-martial, not even a proper court, and found guilty of murdering another stoker named John Riley. They were sentenced to be hanged. After a long series of appeals, including one to the High Court, their death sentences remained intact. They pleaded their case to the King, who exercised mercy and commuted their death sentences to sentences of life imprisonment. As an aside, Elias and Gordon were actually released from prison in 1950, and there are still many questions unanswered about the death of Stoker Riley. It seems likely that Riley, Elias and Gordon were homosexual and were involved in trysts with one another. Homosexuality at that time was, of course, a criminal offence, and yet somehow this issue was not mentioned at all in their court-martial. For us, though, the point here is that the powers of mercy and pardon are prerogative powers. The Queen, the Governor-General and the state governors simply get to decide. No one can tell them how, no one can second guess them, no one can review their decision. The authority for prerogative powers is a British case called Council of Civil Service Unions against the Minister for the Civil Service. In that case, the Minister, Margaret Thatcher, said that intelligence agency employees were not allowed to belong to the union for security reasons. The union challenged this, but the court upheld the minister's decision because the court found that it was a prerogative decision. Finally, decisions which are made by national security agencies or law enforcement agencies are not going to be reviewable decisions if reviewing those decisions would compromise national security or criminal intelligence. We could see this in operation in a case called K Generation against the Liquor Licensing Court. In that case, the police advised the liquor licensing authorities that a particular applicant was not suitable to hold a liquor license. He challenged that decision, but the challenge was set aside because it would have required the police to reveal their intelligence sources, and that was not in the public interest. So, where does all of that leave us? For administrative law purposes, what is a decision? Well, a decision can include an actual decision, conduct related to the making of a decision, provided that conduct is final, operative, and determinative, and not just a mere stepping stone to the final decision. And a decision can include a failure to make a decision within a reasonable time. However, rulemaking is not a decision, prerogative decisions are not decisions, and decisions relying on secret national security or police intelligence are not reviewable decisions. So far, in week 2, we've talked about how courts and tribunals get jurisdiction to review decisions. We've talked about the fact that decisions are reviewable if they are decisions of an administrative nature made under an enactment. And in this video, we've drilled down to see what we mean by a decision. In the next video, we're going to ask what we mean by a decision of an administrative nature. Until then, though, go have a break. You've earned it.